of station, my lord, due to some personal difficulty.
You see,
So-
Supreme Court has some time back, long time back in fact, has said that being out of station cannot be made an excuse for
But,
adjournment.
due to some personal difficulty, he is out of station. And we have taken the consent from the.
Okay, right. On the prayer for adjournment made on behalf of Mr. M. Datta, who is having some personal difficulty. And as the same is not objected to by Ms. S. Jahan, additional PP, this is the matter. After,
Any date, my lord,
after 2 weeks.
much obliged.
May I please, I beg to match item number 12, Lordship, of supplementary list. Lordship, matter will be taken next week, Lordship.
Why?
Lordship, my senior personal difficulties, Lordship.
You wait, you wait. We have to issue notice. Just wait. Just wait. Just wait.
Nice, Lordship.
May I please, your Lordship?
Huh?
May I please, your Lordship?
Yes.
Lordship, I beg to mention item of 2, hearing is Lordship.
Item number?
Item 2, Lordship.
Yes.
So, in this case, also kindly adjourn the matter for today, Lordship.
Why?
Lordship, dealing counsel, Mr. A. Khattas.
Huh?
Dealing counsel, Mr. A. Khattas is a Lordship. He is not prepared today.
He's not prepared today.
Yes, Lordship.
He's not prepared.
Yes, yes.
So when will he be prepared?
After 1 week, Lordship.
After 1 week, he'll be prepared. After 1 week and between how many weeks? Or between how many?
After 1 week, Lordship.
After 1 week can be after 1,000 weeks also.
No, Lordship.
What is the upper limit, outer limit? Within how many weeks will he be prepared?
After 1 week, Lordship. Any date, Lordship, except 22 and 23.
It's like saying, I can eat more than 10 tomatoes. How many tomatoes can you eat? You'll answer, I can eat more than 10 tomatoes. You're not saying how much you can eat. They're only saying how much you can eat. You have to give an outer limit. You can eat 20 tomatoes, 19 tomatoes, 15 tomatoes, or 5 tomatoes, or 1 tomato. Similarly, when we ask you when you will be prepared, you are saying that you will be prepared after 1 week. You are not saying that you will be prepared within 1 week or within 2 weeks or within. What is the outer limit? You don't understand the question.
Next week, Lordship. Next week.
Yes. Right. Adjournment prayer has been made on behalf of
On behalf of A. Bhattacharya, Lordship.
Huh?
A. Bhattacharya.
A. Bhattacharya,
Yes, Lordship.
learned counsel for the apparent, which is not objected to by Miss S. Jahan, learned counsel for the additional people.
My lord, Lordship, I am for the respondent number, my respondent number 2, my lord. It's my date by fixed, man.
List the matter. When do you want?
Next week, my lord, immediately.
25 by 24, 23 by 25 by
25 by.
25.
Hours.
Eight.
Hours.
May it please, your Lordship. Lordship, with the consent of the other party, I beg to mention item number 4 and 5 of the cost list. Lordship, that the matter may be adjourned for the day,
Why?
as my senior has to go to Golagat due to the dismiss of his cousin brother.
Due to the
Dismiss of his cousin brother. His cousin,
Dismiss?
but
demise. Oh. Demise. Okay.
sorry.
No, it's okay. It's a serious issue, but then you put a lighter color to it. Anyway, it's just a matter of pronunciation. Should be demise. Adjournment prayer has been made on behalf of Mr.
As Burgoyne,
S. Borgohain, who had to go to
Golagat.
Golagat due to bereavement of due to family bereavement. List the matter.
Lordship, next week on Tuesday.
What is the
22nd.
matter about? What is the matter about
It's
rape, murder, what? Huh?
convicted under 302, my lord.
302 is what? Rape,
Murder.
murder. So we will, when do you want? Tuesday?
Tuesday.
Okay, Tuesday.
In 2nd of August.
Obliged, my lord.
The next matter. 5, 4 and 5. Lodge.
Please, Madam. No, as per the last order,
Item one.
item one. No, as per the last order, Milods, the appellant had gone to the GMC for treatment. Milods, we have filed an affidavit, Milods, and perhaps might not be on record. Milods, we have,
What is this matter about?
Milods, this appellant was convicted under 302. We had filed a 389, Milods, for suspension of his sentence. Initially it was dismissed. Then we filed an
What is the IA?
Milods, we filed an affidavit today, yesterday actually, we had filed it. Just the PP, Milods, can I supply copies, Milods, because it might not be on record. This
He
affidavit.
was on interim bail on medical grounds.
Yes.
And thereafter he was supposed to surrender. And then they had taken 2 weeks more time, extended by 2 weeks more. On the ground that he should be taken to the GMCH and
No,
a report
that's
should
not-
come.
Milods, if I may submit, Milods, the issue is that this person had severe hypertension issues. And we had submitted, Milods, in the IA that he is susceptible to strokes. Now, what has been found by the GMC, Milods, is that he had a stroke only last week. And he was admitted in GMC from 10th of August to 14th of August. Milods will kindly see in this affidavit that I won't just supplied, Milods. Milods will kindly come directly in the affidavit to page number 33, Milods. Page number 33 is the discharge certificates. Milods will see the diagnosis.
Acha, this is the one who had, this is the person who had 2 medical certificates.
Yes,
Yes,
The
yes.
last order, Milods, if that was the observation by this honorable court, and that's why, Milods, we came to the GMC. The GMC, Milods, has observed that he has a stroke. He has had a stroke last week, Milods. That is the observation by the GMC. Milods will see first the discharge certificate at page 33. He has a cerebrovascular accident, in brackets stroke, Milods. That's his diagnosis, and hypertension as well. Then Milods will please come directly to page number 37, Milods. That is the medical certificate which has been issued by the GMC.
He has been discharged on 14/8.
Yes, he has been discharged, Milods. Milods will kindly come to the medical certificate which was issued on 14/8, Milods, at page 37.
Improved. You go to jail. Mr.
No,
Kaushal.
Milods, he has improved. Milods, I'll only show one thing, Milods. Two things, Milods, from this affidavit. Page 37 first, Milods. Milods, the medical certificate says that
Where is your original certificate?
Milods, it's here. Milods, these are the original. These are the original bundles of all the documents. Not there, not there, not there.
Your liver function test,
Yes.
which includes albumin, TP, TB, ALTS. It takes only 410 rupees. I want I have to take my test there also.
Millards, that is one of the reasons why we went to GMC Millards, because this honorable court had Millards directed, and it's fortunately Millards it was not very expensive. But even then, Millards, they had some problems because they come from a very poor socioeconomic background. Millards. His LDH is also high, Millards. LDH, Millards, which is there in the affidavit as well. On the last page, LDH is this thing called lactate dehydrogenase, which when it's high, and the high Millards, the levels are extremely high. Millards. By 300 units, it's higher.
He's 75 years old, Mr. Council.
Yes, yes.
You can't expect him to be
No, Millards, I'm not
and
saying
you,
that he has to be absolutely fit. However, Millards, the circumstances are that he is number one, as Millards have pointed out, 75 years old. And Millards, he is prone to strokes, Millards, which has also been found in the radiology report by the medical hospital. The radiology report says that he has chronic infarct.
what does it say at the bottom? This of the discharge certificate, patient clinically and
Clinically and that's Millards, yes.
Hydro, there is a mistake in the,
Hemodynamically.
there is a mistake in the type.
Yes.
It
That's a
should be-
typographical error. On the next page, Millards, the patient is clinically and hemodynamically stable
And
at
it's
the time
written
of discharge.
stroke. here.
Hemodynamically, Millards. So he has no blood related issue. Page 33 of the affidavit.
at the time of discharge. So he's all right.
No, Millards, he is hemodynamically stable. Millards, that is not my submission that he has any blood related issues. My humble submission before your lordship is that Millards, he has just had a stroke 1 week ago, and he has been found by the hospital to be suffering from chronic infarct, Millards, chronic lacunar infarct. And Millards, because of that, the medical certificate which has been issued, Millards, at page 37, it specifically says that from 2 weeks, he has been advised to take rest from 14/8 to 28th of August, Millards. And he has to be under proper care by the attenders.
Specifying the dates are also a little unusual. He needs rest for 2 weeks and all. Now here from 14 to 28.
And Millards, this is a pro forma and they filled it out, Millards. I cannot now, every hospital, if the prosecution has a problem with, Millards, Morigaon hospital, they have a problem, GMC, Millards, now where will I go, Millards? I have to run from pillar to post every time. The last time they said Morigaon hospital is problematic. This time they have a problem with the GMC pro forma as well. This is their pro forma, Millards. I have not generated that. The original.
Oh, Mr. Council, your last two certificates, that was unbelievable.
Hmm.
No, no, Millards,
okay,
our
I think-
submission is.
So we are of the view that if you are serious, then you go back to hospital under proper security, not at home.
Millards, if I may only submit, Millards, 2 points, Millards, 2 points. On law, Millards, I've shown Millards the medical report, Millards. Those are there, the originals have also been seen. Millards, 2 things, Millards, only 4 judgments I wish to place, Millards, orders of the Honorable Supreme Court, Millards. The first one, Millards, is the 2009 orders, Millards. This is the first one is 2009-11, page 363, Millards. was Anil Ari versus State of West Bengal. The first two judgments, Milord, is on the age aspect only. Now, Anil Ari, Milord, the facts of the case was that there was a conviction under 302. There was a 389 file for suspension of sentence. Milord will kindly come directly to paragraph 8, Milord. Paragraph 8 is on the third page of the judgment. Paragraph 3, Milord. The above portions, Milord, from Placitum A to Placitum E is a quotation from the High Court judge, because the High Court has declined.
Please go to
pass-
the.
Yes.
to
Para
the-
8. In the peculiar facts of the case, considering the age of the appellant, accused Ari, Anil Ari, we direct that he shall be released on bail with 2 securities for the like amount to the satisfaction of the learned so and so in sessions trial number so and so. It is made clear that we have directed release of appellant 1 only on considering the fact that he is 70 years old and not on consideration of the merits of the case. This is number 1, Milords. That in this case, because my humble submission is the appellant before this honorable court today is also 75 years old. That is the first consideration which in my humble submission is relevant insofar as bail is concerned with us. This is a 389 petition is where. Now, Milords will kindly see the second judgment which I wish to place before this honorable court is Bakshish Ram and another. This is also a 2009 judgment, Milord.
How many 389s have you filed?
1 minute.
One.
We had filed 1 initially, which was dismissed, Milords. Then we filed IS for interim bail, Milords, because he started falling very ill.
Initially, there
89
was one,
initially,
I
yes.
got a report that he was kind of stable. Then it was dismissed. After that, they had filed 2, I think,
Yes, please.
2 applications.
We filed 1. order was,
No, one 389 application dismissed.
yes,
Huh.
Then second 389 again filed
we filed for
For
interim
interim,
bail.
yes,
for interim bail,
Yes,
not
for-
for 389.
not.
So for
389.
interim bail, we had filed. That was on health grounds alone, on medical grounds. And on the factor that, the jail authorities, they do not have the proper medical facilities to treat my ailments. That was allowed, he was allowed to go on bail, on interim bail. And then we have filed this instant application, which is for your lordship consideration. For extension of interim.
I think last time was also for extension. Now, extension, there are two,
No. Last time it was, the first one was for grant of,
and that was given.
Yeah.
Thereafter, again,
Thereafter.
extension.
Yes,
And
what
this
is your
case-
other case?
yes, The second one is 2009 6 SCC, page 561, Bakshish Raman, another versus State of Punjab. If I may directly come to paras 13 and 14, same proposition, that if there is a grievous offense as well, but the age of the appellant is in the range of 70 to 80 years, then some consideration, ought to be given to that factor, age. Same proposition, Bakshish Ram is on the same proposition as the previous judgment, Anil Ari.
In your case, how long have you been in jail?
Because I have been in jail for 1 year and 45 days. Till 5th of March, I was in jail. I apologize, 5th of August.
Then
Then, the next judgment, is Ashok Kumar Singh Chandel, This is a Supreme Court order, in criminal appeal number 946947 of 2019. Because in this case, this was also a 302 case, because at page number 2, lordships will see the third paragraph. According to the record, the applicant was on bail while the proceedings were pending before the trial court and the High Court, and he surrendered sometime in May, and he has thus completed 13 months of actual sentence. The assertions in the present application are as under. I'll not go through the entire thing. He had also suffered from a brain hemorrhage. In this case, among other things. Now, will kindly come directly to page number 3. Will see. However, the fact remains. the
brain
appellant-
hemorrhage, he is unable to take care of himself
Yes,
or
yes.
his medication.
In my case also, there is a medical report which says that I need constant attention, by an attender. There is a report, a certificate to that effect. Will kindly see at page 3. However, may I read, However, the fact remains that the applicant is aged about 80 years. And after the report by the medical board, he was examined by so-and-so sometime in March 2020, and the ailments as stated above were detected. Considering the entirety of the situation, we grant bail to the applicant pending disposal of this criminal appeal. The applicant be produced before the trial court within 3 days, and so-and-so, conditions were thereafter imposed.
This
My
is-
humble submission is, that if even in a 302 case, there are some ailments in the appellant which deserve some consideration, which are of some merit, my humble prayer is that this honorable court can consider those and grant interim bail at least, to the appellant. The next judgment, the next order, is a recent order of 2nd of August 2023 in M. Sivasankar versus Union of India. This order, I've only placed. This is special leave petition number 5590 of 2023. This order I've only placed for one reason, just to bring before this honorable court one condition which was imposed by the Honorable Supreme Court. This was also a case where the appellant, he had some health issues. Will kindly come directly. Yes, will kindly come directly at page 2, the second last paragraph, the last 2 lines. The applicant shall not go to any other place except the vicinity of the hospital and the vicinity of his residence. Because these are conditions which have been imposed while granting bail to somebody who is medically seen to be suffering with it.
Out here, he was supposed to go for a surgery.
Yes,
That's
In my case, there is a stroke. Now, in relation to stroke, the last judgment that I seek to place before this honorable court is the judgment, the series of orders which was passed in the famous Italian Marines case, Massimiliano Latorre and others versus Union of India. This is 2016-13 SCC, page 659. Because my humble submission in relation to this judgment is that specifically in relation to a stroke, there was an Italian citizen who was granted time specifically for rehabilitation after he got a stroke, which is precisely my case. Milords will kindly come directly to page 676 of this order. Milords. May I read, Milords? At page 676, para 50. It is stated in the application that the applicant has suffered brain stroke and requires continued management, treatment, rehabilitation, and therapy. On humanitarian ground, therefore, it is submitted that applicant may be permitted to go to his home country, Italy, for about 4 months or so. In support of the application, medical documents have been placed on record. Now, my lords, at the next page, at page 677, para 53, having considered all the relevant aspects, we are of the view that the applicant may be permitted to travel to Italy for his treatment, rehabilitation, and continued management for a period of 4 months from the date of his travel from New Delhi to Italy. For the above period, condition so-and-so in the order date so-and-so shall remain waived. The bail conditions were waived in this, Milords, but my humble submission is, Milords, that in cases of a stroke, where an individual requires rehabilitation, Milords, as the present applicant before this honorable court, my humble submission, Milords, my humble prayer before your lordship, is that not an entire bail, even if not a regular bail for the entirety of the period of disposal of this appeal, some time may be given, Milords, so that he can be only rehabilitated. Even in the IA that we have filed, Milords, our humble prayer before this honorable court is that 4 months time be granted because he is suffering from stroke, Milords. And my radiology report says that I have chronic infarct, Milords. I'll suffer from strokes recurrently. Last submission, Milords, is that my pleaded case is that the hospital does not have the proper medical facilities to treat me. That's there in my first application under first application for interim bail. And even in the second one, the latest one, I've said that I cannot be treated in the jail hospital. They do not have the facilities.
Yes, madam.
In fact, every case has its own facts. Now, whatever case he has placed has its own facts. And what I knew is age can be a factor along with the others, like gravity of the offense, nature of acquisitions. Those has to be considered while allowing application under 389. Age can also be a factor. Now here, seeing the reports, of course, the ultimate result is that his blood flow is found to be stable. And it is also said that he is ready to resume his duties. He is ready, otherwise.
Milords,
Resume
that's a
his
pro
duties.
forma, Milords. Every report
As
says
per, just a minute, please sit down.
yes, Milords.
So in
As
those
per-
facts, as per, it is there ready to resume his duties. It is there, page number 36. Fit to resume his or her duties. Page number 37 is the original.
Correct.
The last line. Actually got it. Now she is fit to resume his duties. This is a part of the form, or otherwise he would have written not.
Maybe we'll ask this doctor to appear before us.
Whether it's a form or he should otherwise write not. But in these facts, perhaps there are facilities in jail, he'll be taken from there to whatever hospitals it requires. But he was on interim, and the condition for the last order was that he was supposed to be taken to the hospital. Now, when he had a stroke or whatever it is alleged, he was then taken on 11th, on 10th. And 14th, after 4 days, he was released. Otherwise, what is shown is a stroke, cerebrovascular accident. Now, this cerebrovascular accident also can mean improper flow of blood and all. May not be a stroke always, but it's written stroke, so I will not dispute on that. But 4 days he was released. And then we already had that in our mind that there were 2 certificates on the earlier occasion. So that is already there. There can be a way, let him surrender. I'll get a report from the jail immediately. 1 or 2 days.
Or should we? Okay.
Those that are already reported. I'll only submit this if I can rejoin minutes with your kind permission. Now, number one, Milord, what she has said about that remark that he is fit to resume his duties. It is crystal clear, or even more than that this is a pro forma of the GMCH. Milord will see the original one at page 37. This, Milord, what he had to write with his hand, he has written that he needs to be under proper care by the attender. Otherwise, everything, Milord, it is absolutely clear that this is a pro forma. They give it to everybody who is discharged.
Hospitals, they can get that.
Yes, Milord. My submission is that if I have to go to the hospital, I have to be under the care of an attender. And in the jail, Milords, it's not possible for me to be under and this submission that if I have to surrender. Milords, a condition, if Milords will consider, Milords, a condition may be imposed that I'll not even leave my home, Milords, except for medical treatment. I'll come before the court at any time, Milords, before the learned sessions court, at any time. But Milords, the fact that he has suffered a stroke only last week, Milords, that may be considered, Milords, and only for a limited period of time I may be granted bail, Milords. I'll come after this period is over, Milords, even if I may submit, Milords, till 28th also, even if I may be given time. Because I need this time as per the hospital itself, Milords, that I need rest till 28th. After that, Milords will grant me the liberty to show with new documents. If I'm fine, Milords, I'll go back.
It appears that you are fine. That's why you have been discharged. No one,
No,
no one discharges a sick man.
No, Milords, I have improved, Milords. That is not my case. Milords, I have not said that I'm cured. It does not say that I'm cured. Milords will see in this application at page 33, Milords.
So you go to hospital, let them have a thorough checkup.
Milords, I'll go to the hospital, Milords. Now, Milords, the fact is they've discharged me.
Let
Milords,
them, huh?
Milords, it's a question of money as well. I'll humbly submit, Milords. These people, Milords, they are not rich enough to come to GMC every time, Milords. My humble submission is this, Milords. They live in Morigaon. If they have to go to Morigaon Civil Hospital, Milords, they're absolutely fine with that. They'll go to Morigaon Civil Hospital. Milords, commuting to Guwahati and getting admitted at GMC is not possible for them, Milords. It's a reality, Milords. It's their reality, Milords. I'm only humbly submitting, Milords. We have instructions on that they can't travel to Guwahati, Milords. Morigaon Civil Hospital will be appropriate for them, Milords. If that is allowed to me, Milords, he'll get admitted. Because he requires that care, Milords. That's the truth.
Where is the dismissal of your earlier 389 application?
Yes, Milords. Lords will kindly see there was an IA which had been filed previously with us.
Earlier I.
Yes, Milord. This is IA criminal number 646 of 2023. This is the same IA, Milords, which Milords are seized off at this point. No, Milords, this is not the one. I apologize, Milords.
Is there any more file?
Yes, Milords. Milords, in my first, this is order dated 24th of February 2023. In IA number, yes, Milords. IA criminal number 481 of 2020. 481. This was my 389 application. The order, in fact, was authored by your ladyship, actually. It was 24th of February 2023. The same bench, this honorable bench. Even in this order, Milords, I'll only humbly submitted paragraph 13 at page 7. This honorable court had noted that at that point of time, Milords, the medical issues were blood pressure, vertigo, and migrainous headache. So the submission of the prosecution, that even at that point of time, she submitted a report, it does not go on to show anything, Milords, insofar as his present conditions are concerned. He did not have a stroke at that point of time. He was not diagnosed with hypertension. This goes on to prove my point, Milords, that the jail hospital is not competent to deal with these kinds of cases. They diagnose him with blood pressure, vertigo, and migrainous headache. Not even hypertension, Milords.
So. So. This order. Correct. Heard Mr. D.K. Bhattacharya, learned counsel for the,
Milords, A Gautam.
Huh?
A Gautam, Milords.
A. Gautam, learned counsel for the applicant. Where is Mr. So you are a new counsel here for today.
Milords, I assist Mr. Bhattacharya, otherwise he is unfortunately
Okay.
indisposed today.
A. Gautam, learned counsel for the applicant. And Miss L. Jahan, learned additional people. Next para. The applicant's counsel submits that the interim bail granted to the applicant should be extended in view of the fact that as per the medical certificate dated 14/8/2023 issued by the GMCH the applicant was in hospital from 10/8/2023 to 14/8/2023 due to cerebromuscular accident (stroke) and was required and was advised bed rest from 14/8/23 to 28/8/23 under the care of an attender. The applicant's counsel submits that in view of the above medical certificate. No, the applicant's counsel submits that though, what have you filed application? What have you filed before the registry today?
An affidavit, additional
Submit that though an additional affidavit has been filed before the registry, the same is not on record. As on record. He however submits that as the applicant has been advised bed rest in his home for 14 days, he should be allowed to. His interim bail should be allowed to be extended. Ms. S. Jahan, learned additional PP, on the other hand, submits that as per the medical certificate dated 14/8/2023 produced by the applicant's counsel, the applicant is fit to resume his duties. And as such, as this court had while order dated 2/8/23 directed the applicant to surrender before the concerned jail authorities come. The applicant should surrender before the jail authorities. That's all. Anything else? We have heard the learned counsels for the parties. The applicant had been convicted under section 302 IPC. While judgment dated 2/6/2022 passed by the learned session judge, Morigaon in sessions case number 24/2050 and was sentenced by order dated 8/6/2022 by the learned trial to undergo a rigorous imprisonment for life with a fine of rupees 50,000 in default, simple imprisonment for 1 year. Next paragraph. The applicant filed an appeal, that is criminal appeal 204/2022, and an application under 389(2) CRPC for suspension of the sentence and bail, while IA criminal 481/2022. Next paragraph. This court dismissed IA criminal /481/2022 by holding that the applicant had given a blow on the head of the deceased with a spade, which caused the death of the deceased. Further, this court also came to a finding that as per the medical report submitted by the medical and health officer, district jail, Moregaon, the medical ailments of the applicant was not found to be serious in nature. Next one. Subsequent to the above facts, the applicant filed IA 421/2023 praying for bail on the ground that the applicant was suffering from high blood pressure from a continuous headache on the left side of his head, migraine and other related problems. This court wide order dated 2/6/2023 passed in IA Criminal 421/2023 granted interim bail for 2 months to the applicant with effect from the date of his release. This court also directed the applicant to surrender before the concerned jail authorities on expiry of 2 months. The next. So this has been disposed of. It is disposed of.
421 is disposed of.
For disposal of. For disposal of the. Disposed of. Thereafter, next para. Thereafter, the applicant filed IA criminal number this is a problem here. Okay, so criminal number 469/2023. Seeking clarification of the order dated 2/6/2023. Passed in high criminal number 421 of 2023. The clarification sought for was with regard to the conditions required for grant of bail and which court would be the competent court to accept the bail bond of the applicant. IA 56/2023 was disposed of. No, IA for criminal 469/2023 was disposed of by order dated 5/6/2023 by holding that the applicant was allowed to go on interim bail for 2 months on a bail bond of ₹20,000 with one surety of like amount to the satisfaction of the learned session judge Moregaon in relation to the order dated 26/2023, passed in IA criminal number 421/2023. Pusta. The applicant was thereafter released on bail. In terms of the orders passed in IA 421 of 2023 and 469 of 2023. Pusta. Next paragraph. Subsequent to the above facts, the applicant filed IA criminal number 646/2023. Praying for extension of the interim bail granted to him by a further period of 4 months. Pusta. This court passed order dated 2/8/2023 in IA criminal 646 of 2023. Allowing extension of the interim bail granted earlier up to 16/8/2023. This court also directed the applicant to surrender before the jail authorities on 17/8/2023, that is today. This court further held that the applicant was to go to the GMCH for better investigation and treatment, and the report therein was to be submitted to this court. This court, in its order dated 2/8/23, passed in IA criminal number 646 of 2023. Also evoked surprise with the fact that two advice slips had been issued on the same date by the same doctor against the applicant. On the basis of which the period for on the basis of which extension of the period of interim bail had been paid for. Further, the advice given on the two advice slips made by the same doctor against the same patient on the same date was different. Pusta. Next paragraph. Today, the learned counsel for the applicant has stated that he has filed a affidavit giving a report with respect to his medical examination conducted by the GMC. Though the affidavit is not in the records, he has provided photocopies of the documents. On perusing the discharge certificate dated 14/8/2023 issued by the GMCH to the applicant, it is seen that he has shown to have improved and the diagnosis against him was that he had cerebrovascular accident, stroke, not muscular. I said muscular, only vascular stroke. Further, it stated that the applicant was clinically and
Hemodynamic.
was clinically and hemodynamically stable.
Yes.
Hemodynamically at the time of discharge.
Hemodynamically means a flow of blood.
Ah.
That is found to be stable.
Full stop. The medical certificate dated 14/8/2023 issued by one Dr. Subhajit. Who's this?
Mitra, I think.
Neha
Mitra, I think.
Huh?
Mitra, I think.
Mitra.
Mitra.
Yes.
Mitra,
Was the answer.
Assistant Professor of Medicine, GMCH, is to the effect that the applicant was an indoor patient from 10/8/2023 to 14/8/2023 and was suffering from cerebrovascular accident, bracket stroke. He was advised to take bed rest. He was advised to take rest, not bed rest, advised to take rest for 2 weeks, with effect from 14/8/23 to 28/8/23 under the proper care of an attender. Full stop. What is it? But he doesn't have to. Doesn't have to.
Otherwise, releasing on interim bail on ailment needs very close scrutiny, very.
Yes, and now there's nothing here,
Okay.
nothing left. Nothing is left.
Plus, his radiology report is also there on record. It says that he has chronic infarcts. That means
Chronic?
chronic infarct. That means he's susceptible to regular strokes. Because we have
Everyone is susceptible, Mr. Kausar. I
because,
mean,
because there are documents which say that lacunar strokes, they means after the age of 70 minutes, it means that you become very susceptible if there is white matter problem, which the radiology report
Full stop.
specifically concludes.
Next para. In the case of Anil Ari versus State of West Bengal, 2009-11 SCC 363, cover. The Supreme Court had granted bail to an appellant accused, considering that he was 70 years of age. In the case of Bakshish Ram and another versus State of Punjab, 2009, 6 SCC 561. The Supreme Court had granted bail to an old lady of 80 years who was suffering from various age-related ailments. Full stop. Both suffering from stress and who had been in jail for a year. The earlier one also, huh? For a year. In the case of Ashok Kumar Singh Chandel, First State of UP, Criminal Appeal number 946-947/2019. The Supreme Court had granted bail to the applicant who had suffered brain hemorrhage, due to which he suffered from amnesia and was unable to take care of himself or his medication. In the case of M. Sivasankar versus Union of India and another, special leave to appeal criminal number 5590/2023. The Supreme Court. Actually, no. IA number 135251 of 2023. Had granted bail to the applicant for 2 months, as the applicant had been advised surgery to the spine and had directed that the applicant would not go to any place other than the vicinity of the hospital or his residence. Gustav. In the present case, the applicant is 70 years of age, 75 years of age. Is apparently 75 years of age. Gustav. The above being said, the reason given for grant of interim bail was only on medical grounds. However, the documents submitted before us, that is the discharge certificate and medical certificate, both dated 14/8/2023, show that the petitioner, that the applicant had a stroke and had improved, and that he was stable. Had improved further. He was clinically and hemodynamically stable at the time of discharge. Though he was required to have rest for 2 weeks. We are of the prima facie view that the appellant, that the applicant is medically fit to be incarcerated in judicial custody. However, no, what do we do? So, however, we are of the view that a full report should be given by the cardiologist.
Neurologist.
Neurologist. By the neurologist of GMCH hospital. Accordingly, we are of the view that if the petitioner is required to take rest under the proper care of an attender as per the medical certificate dated 14/8/23. He should be admitted into GMCH hospital,
Moregaon Civil Hospital would be possible.
GMCH hospital. Full stop. Thereafter. The, comma, GMCH hospital, comma, wherein a full report should be made with regard to the condition of the applicant. Accordingly, list this matter on 20,
20.
today's what date?
Today is
17.
17,
No,
20 is Sunday. 22nd, 23rd.
accordingly, list this matter on 24.
Because if I have to come to GMCH, till 24th, may I be given time so that I can come and get the report done.
Hmm?
The interim may be extended till 24th so that I can get the checkup done. Only till then. I can come here and get the full report of the neurologist.
Yes, you have to come here.
Yes.
You have to go to the hospital.
Yes, yes, I'll come to the hospital to GMCH.
Yes,
So I may be allowed to come here on bail.
yes, yes.
Because have said that I am fit
Huh?
to undergo incarceration. But my interim may be extended till 24th.
Right, what have we said? Full stop. It is made clear that the applicant should admit himself into hospital by
3 days time may be given.
you said 2 days. Today.
Because I very humbly
By-
coming here, there are
by-
financial issues. They have to arrange some money.
By 19/8/23. By 19/8/23. And consequently, the interim bail is extended up to 24.
Correct.
24/3. 24/8/23.
The matter will be listed.
This is the matter on 24/8/23.
No, you will bring the report.
Very well. We'll place the
No,
report.
he'll bring the report.
You have to bring the report on
Very
that
good.
date.
I'm very grateful. Can we take the original records, please?
Yes,
Oh, yes.
yes.
I'll pray for that.
In fact, in the medical report, it's written that consultation was made with the neurologist and it was taken. So that of course is not
Which one?
for your lordship.
What?
That it's written in one of the certificate that the neurologist was consulted and a report opinion was taken.
No, no, Milord. He was referred to neurology OPD, outpatient.
But then
department.
it's written in the opinion taken.
Let us see, let us see.
Page number 33, neurology call and opinion taken.
So already taken, then why are we doing it again?
It was
Yes,
taken, let,
That,
But the
Milord, the
neurologist-
radiology report says that I have chronic impact. That's what I'm pointing
that
out. Milord.
report is not before your
No,
lordship
no,
today.
Milord, that is there
So-
at page 30. That's what I was saying, Milord, at page 38. That report is there of the affidavit. The entire radiology report, which says that I have chronic infarction, regular infarction, I have white matter.
This
item
is the
changes.
radiologist.
Yes, Milord, that is the neurology report, Milord. It says CT scan, brain plane, Milord, OPD. This, he was referred to the neurology OPD. After that, he got this done, which says that he has chronic infarct, my lords, in his brain. He's susceptible to a stroke, my lords, all the time. The first 3 bullet points at page 38, my lords, of today's affidavit.
The type copy, but it's the original.
The original is on the next page, my lords.
It's not legible at all. In
Yes,
my
because
copy, it's not.
we have the original copy as well.
Just the original.
Here, my lord. The original copy is this one.
This is finally finalized and approved by the radiology. May let the neurology full report come.
Very well.
Then Lordship can see.
As the learned prosecutor is right that he was eventually referred to the neurology OPD when he was leaving. In the prescription, it's noted. But that is what managed. Page 35.
Anyway. We'll see.
Right.
2 minutes.
The original record.
No. And she had realized herself. I never realized she wanted one robot. No. I'm going to find it. मैं ऐसा बोल
Kuntal, you are the one who took the dictation? No. We'll make a slight change. We'll say that the superintendent will furnish a report, not him.
अच्छा superintendent will furnish it. That would be better.
Yeah, the superintendent will.
And registry will get it.
Registry will get it. Oh, yes, you're there. You see, we'll ask the superintendent to furnish the report,
Very well. Very well.
but you'll be there on 19th.
Very well.
And the registry will bring it.
The
Very,
He
registry
doesn't have
will-
to do anything.
very grateful. Very grateful.
Item
Item
11.
11.
Yes.
The interrogative application is there for suspension of sentence and grant of bail, Lordship. And Lordship may only see that he is convicted under section 376 for 12 years. Dear Lordship, at the time of incident, the appellant was 20 years old and the victim was 48 years old.
Victim was 48 years.
48 years. And if
So?
your Lordship see the evidence of her recorded as a PW7, your Lordship will find that she said the incident occurred in dark. She did not see the face of the accused. And FIR was lodged by some other villagers, and she did not disclose the identity to them about the accused.
So, but then,
That
so
identification.
do you have to see a person to know which person it is? Can't you recognize a person by voice?
No, that is not there.
Or
She said
some,
she did not recognize.
yeah.
Lordship may only see the evidence of PW7.
Anyway, the, out here, okay, this is 376.
Lord.
PW7, let us see.
In the record, or I have the Xerox copy, I can provide.
Yeah. So, this is the, so we are on the IA.
The live stream.
Has the live stream has stopped? Have the records come?
Records.
The paper book will have to be made. Yes,
PW7, Lordship may.
yes.
We were under the impression they'll take an adjournment, that some signature was taken from us yesterday, but which matter? It's okay, I have gone through this matter before.
The conviction is under 302 million for life. Two zero one 1 year, madam.
How many persons?
Two accused persons, madam. One appellate is acting as 6, one appellate acting as 7. Madam. And 392 for 10 years. Madam. Page 4 is the FIR. Madam.
So your case is 302, 201,
392. Madam.
392.
Page 4 is the FIR. Madam.
Dated,
FIR is 18/1/2012. Madam.
filed by whom?
Filed by PW3. Madam.
Who is he?
She is the owner of the stolen vehicle. Madam.
So who did you kill?
Look, before Lordship, my lord, the first FIR, my lord, was lodged by PW1, my lord, on 17th, my lord.
No, but out here, what is the case about? The driver was killed
The driver was killed, my lord. PW1,
and you were found in the car.
we were found not in the car, my lord. We were found in Halupung Gate, my lord. We were stopped by Arunachal police, my lord. We were found
You were
next to the car,
stopped in the, you were stopped in the, by the Arunachal police in which car?
in the stolen car,
In
my
the
lord.
stolen car.
Stolen car, my lord. But my lord, when the police came, my lord, we were not in the car, my lord. We were next to the police. We were not detained or handcuffed or anything, my lord. We were just standing there.
No. When you were stopped, you were in the car.
No, that is
Or
it.
you were walking towards, where were you walking? When you were walking or you were driving, you were in the car?
The prosecution version is that we were driving the car and we were stopped, my lord.
According to you, you are walking along the road, highway. Where?
We have produced defense witnesses, my lord. They say that, my lord, we were in a car, my lord. We were going towards Arunachal, my lord. since we did not have the gate pass, we were made to come down, my lord. Devote the vehicle, my lord, and there we stop, my lord. GW 1, 2, and 3, my lord.
Huh?
GW 1, 2, and 3, my lord. Defense witness 1, 2, and 3, my lord.
How many appellants in both convicted under the same
Same, my lord.
sections?
There is no 34, my lord. For both
Not
convicted,
34, only 302, 201 and 392.
no common intention.
And so both of you convicted under
My
that.
lord.
Common intention charge is
Charge was there, but no conviction, my lord.
Charge was there under 34.
My lord, but no conviction, my lord, no finding, my lord.
So charge under section 302, 201, 392 and 34 was also there. Correct?
Charge is page 102, my lord.
Charge is not 102.
392, 302, 364.
So 364 is there also. You did not mention
No, that's
364.
acquitted, my lord.
Huh?
Acquitted, my lord. 360.
364 acquitted. Okay, so wait a minute. Charge,
charge is at page 6.
page 6.
I don't have to.
Page 6 is. Yeah.
Page 6 charge 30, okay, with 34. 201. Okay, all with 34.
All with 34.
All with 34. So all 34 is included.
Doing conviction, my lord, that sentencing, no 34.
That 34 is not mentioned.
Not mentioned.
So does that vitiate anything?
No, there,
What
should
does it cause you any prejudice?
there should be a finding for 34, my lord. That with common intention, the appellants committed the crime.
No finding.
No finding, my lord. Page 4 is the FI, my lord. Altogether, there were 22 PWs, my lord, and 3 defense witnesses. Page 4, my lord. May I read, my lord?
Yes.
With due respect, I beg to submit that around 8:05 p.m. on 17/1/2012, 2 persons, namely Shri Jan Das of Alipara and Shri Bhaskar Nath of Besaria, present appellant, my lord, took away my Maruti Alto car bearing registration number so and so along with the driver from Balipara Center. And later they killed driver Mohammed Dinu Ali and fled along with the car. Later on, after making a search, we, some 4 persons, apprehended both of them along the said car at Bhalukpung check gate and handed them over to Bhalukpung police check gate. Page 8 is PW1, man. He is the husband of the informant, man. He lodges the first FIR, my lord. In the first FIR, my lord, no one is named, man.
Husband of
The informant, my lord, PW3, my lord.
PW1 is the husband of
PW3, man.
PW2.
Well, he lodges the first FIR, my lord, that no one is named, man. He says he lodges the first information that, my lord, my car is stolen by someone, man. There no one, these person's names are not there, man. DDNT was there.
So
man.
where is the earlier FIR?
That is not exhibited. Man. DDNT number is there, my lord. It comes out in the
So
evidence.
it might be just information for the purpose of a GD entry.
My lord, but investigation started from that DDNT, my lord.
So how does it matter?
So this FI would not be an FI, my lord. It would be hit by 162, my lord. Because investigation started on the basis of the first.
Yes,
The first DDNT would be the FI, my lord.
Provided certain facts.
Everything was done on the basis of the first DD. The accused were arrested, the vehicle was recovered, And the dead body was also recovered, my lord. That comes in period 21 and 22, my lord. IOs.
If lot of investigation has if it underwent after the GD entry, then of course GD entry will be considered as an FIR, I think. That is the enough safe Supreme Court judgment is
Not exhibited, my lord.
not exhibited. Acha.
Well, the true genesis of the occurrence is clouded in mystery, my lord, because PW1 would say that my car is stolen. PW3 would say that 4 would say that PW1 has come, told me that his car has been taken away by his driver, and he wants to go and search for his driver, my lord, along with the car, my lord.
Naturally, he will first blame his driver. Naturally, because he would have thought, because driver is the one who takes it away.
My lord, PW then 1 says that my car is not a taxi. PW7 says his car is a taxi, was given on hire, my lord. The genesis of the occurrence, my
They are
lord, is-
making money on the sly, that's all. They don't want to show to the authorities that they're actually using it as a taxi.
but that
And
true
that
genesis,
doesn't
my
take
lord,
away the fact that there was a murder.
my lord, the true genesis, my lord, how the vehicle was taken away, that is not there, my lord. That is a humble submission, my lord. PW1, my lord, page 8, my lord.
Yeah.
On 17/1/2012, my lord, at about 8:05 p.m. at night, our car, which is in the name of my wife, Vinita Soikia Rotto, PW3, my lord, bearing number so and so, Alto, blue color, was taken away 2 persons from before my pharmacy. The driver was there in the car. We were looking for the car. I came to know that Bhalukpung police recovered the car at Bhalukpung gate from Jandas and Bhaskar Juti Nath, appellant, my lord. And driver Dinu Wale was not in the car at that time. Saridwar PS brought the said 2 persons from Arunachal police. I came to know that Dinu Wale, the driver of the car, was murdered by the said 2 accused persons. The accused persons themselves showed where they had kept the murdered body of Dinu Wale. Thereafter, I went and gave the FIR. The FIR was written by my wife. Since she was 5 months pregnant, she did not go to the police station to file the FIR. Well, the case was primarily on 27 Malur leading to discovery. Cross Malur. Accused were caught in Bhalukpung by Arunachal police. I had gone to Bhalukpung in search of the car. Arunachal police informed me about the recovery. Accordingly, later, FIR was given. I did not see who had taken the car from Balipara center. Our car is not a taxi. We did not use it to give on lease. I informed Charidwar PS immediately over telephone about the fact that my car was missing. Asim, PW5 Malur. This is another Jan Malur. This is PW4, and myself had gone to Bhalukpung after Charidwar police informed me that the car has been recovered. The accused persons were caught by Arunachal police. They were caught when the car was proceeding towards Arunachal. The accused, while in custody of police, admitted before police that they had murdered the driver. The accused led the police to the spot where the driver's body was kept. The accused were taken in the police car while they led the police to the spot. I do not remember whether the accused were handcuffed. After FIR was lodged, police took my statement. Police went to our house and recorded the statement of my wife. I was there with the police since the night of occurrence, and we returned together from Bhalukpung along with the accused persons. It is not true that I have deposed falsely that the accused admitted before the police that they had murdered Dinu Ali. It is not true that the accused did not lead the police to the spot where they had kept the body of Dinu Ali. It is not true that because I have full enmity with the accused person, I have falsely deposed in the court today. It is not true that the accused is not related to the incident case. I do not know how our car was taken from the center. The driver was there with the car at that time. Well, PW2 is the postmortem doctor, my lord. He says that in his opinion, my lord, the cause of death was due to asphyxia and cardiac arrest due to throttling or manual strangulation. My lord. And my lord, he had found multiple fingernail abrasions on the lower neck part of the neck, my lord. PW2, my lord. PW3, my lord.
Just a minute.
And my lord,
Just
PW,
a minute.
my lord.
Then deliberations. No, it's, what is wrong? When someone is choking you with triangulating you or choking you, you'll try to remove it. It can be self-inflicted.
Malad, malad. That malad, but malad, that two appellants, malad. No 34 is there, malad. PW3, malad.
Huh?
PW3, she is the informant, malad. The owner of the vehicle, malad. Malad, I know Kumud Das, the accused. My Mohammed Dino Ali, deceased, was the driver of my husband's car. On so and so, my car was robbed, malad, from Balipara Center. The two accused forcibly took away the car along with the driver. Hello, kindly see the two accused forcibly took away the car along with the driver. While they were proceeding to Arunachal Pradesh, they were caught by Arunachal police at Bhalukpung gate. Charidwar police went and brought the car and the two accused persons from Bhalukpung police station to Charidwar police station. On investigation, police found the dead body of Mohammed Dinu Ali in the Jia Bharalu river. On 18/1/2012, filed an FIR in the Charidwar police station. Exhibit so and so is the FIR. Exhibit so and so is my signature. The cross, malad. I was the registered owner of the Alto car. It was a personal car. We never gave the said car on rent. On the date of occurrence, my husband was using the car in connection with business purpose. He is a MES contractor. On the date when the car was lost, we went and gave complaint to the police at Saridwar police station, and police asked me questions. We came to know that Arunachal police had recovered the car with accused persons, and police informed us. Charidwar PS brought the vehicle and accused persons to Charidwar. We came to know about the accused persons from the police. Hello, kindly see, accordingly, on being told by the police about the names of the accused persons, I gave FIR exhibit number 2. Police did not record my statement after lodging on exhibit number 2. On so and so, when we complained before police, at that time we did not know the names of the accused person. I had not gone to the police station to lodge FIR since I was pregnant. My husband had gone to lodge it. I had not seen the police bring the car and the accused from Charidwar. Police did not meet me after lodging of FIR. I had not informed the police that the accused had taken the driver of Alto and car to Arunachal. Police had informed us about the same, and then we came to know.
How long are you going to take, Mr. Counsel?
Malad,
If you're going to read each and every deposition like that.
There are 20.
22 are there, malad.
22, we are going to take the whole day.
No, 1 to 11 are there because they all talk about discovery, malad. Then malad 12 and 13, they were the videographers, malad. The police made the accused person reenact the scene, malad.
So how long are you going to take?
No, there are 22 people.
But don't have to read each and every even.
Malad, because then I will skip, malad, but Lordship will kindly see, malad, the 1 to 11, malad, they have not said the exact words spoken by the accused persons leading to the discovery. And Lordship will also kindly see, malad, there is no discovery memo, malad. There is no discovery panchnama, malad. There is no 164 statement, malad. Then I will skip some parts, malad. Then 1 to 10, malad, no, the exact words said by the accused persons leading to the discovery, malad, has not been said by the witnesses, malad. That is necessary, malad, to prove the leading to discovery, malad.
Who says the exact words are necessary?
Certain judgments are there, my lord. And my lord, law has developed to that point, my lord, that there has to be a discovery memo, my lord.
Not
It has-
required.
It has to be 3-judge bench, it's region Supreme Court, my lord. It has to be written down, my lord, the exact information, my lord. Prior to recovery, my lord, and only that part which shows the discovery of a new information, my lord, that would be admissible, my lord, but that is missing in this case, my lord. And the other thing taken by learned trial court below to convict the accused persons, my lord, is their confession before the policeman, in the presence of policeman.
So your first case is that there was no discovery memo, correct?
No discovery
Right.
memo, my lord.
Then number 2,
Number 2, my lord, the witnesses, the Panchnama witnesses, my lord, or the IO even, my lord, has not said the exact words leading to the discovery, my lord, said by the accused persons, as deposed by the accused persons, leading to the discovery of the dead body, my lord.
leading to the discovery of
the deceased, my lord. And the deceased, my lord, was not found in a hidden place, my lord. He was found on the bank of a river, my lord. Open bank, my lord. And the witnesses are also not clear on the point which place he was discovered, my lord.
disease was found where?
Some Bhorali river, my lord, bank of the river, my lord. The witnesses, my lord, they are not even corroborative to the part that where the body was found. Bank in the water, my lord. Someone says next to an idol, my lord. It's all not corroborative, my lord. And then, my lord, the witness, the accused person's confession before the police was used as a circumstance to convict the person, accused appellant, my lord.
Yes, what did you say?
The confession of the accused appellants, purported confession of the accused appellants in presence of police, my lord, has been used as an incriminating circumstance to convict us, my lord.
Confession in the presence of police.
Yes, my lord, 8 by section 25 of the Evidence Act, my lord. My lord, one more thing, although it is not mentioned in the those particular circumstances given by the under trial court, my lord, the videography part, my lord, of PW 11 and 12, my lord, the learned trial court has derived satisfaction from that the videography itself would show that they had committed the offense, my lord.
Videography of
Of the reenactment of the leading to discovery of the body, my lord. That was done much later, my lord. That would itself show that, my lord, the witnesses had not deposed the exact words how the body was discovered, my lord. Because, my lord, the incident is of 17. As per the prosecution, the body was discovered on 5:30 AM in the morning. Videography was done on 22nd of same month, my lord.
incident occurred on
17/1/2012, my lord.
17/1/2012
12:30 PM, they were stopped. 12:30 PM, they were stopped at Bhalukpur gate by
on the same day.
on the same day.
Stopped on 17/1/12 at what time?
In the night, my lord, 12:30 at Bhalukpur gate was stopped by Arunachal.
12:30 night.
Bhalukpur
Then
checked it.
body recovered on
Body recovered on 18th, my lord, 5:30 AM in the morning, my lord. 5:30 to 6 AM in the morning, my lord. Videography was done on 22nd, my lord.
Huh?
Videography was done on 22nd, my lord. The confessions were also videographed, my lord. In the police station at Esport Sadar police station, my lord. Purported confessions, my lord. They were played in the court as material exhibit 1 and 2, my lord.
confessions under 164.
No, my lord. In 161 confessions in a different police station were recorded, played before the court.
Statements, that's not confession. Those are statements.
The learned court below, my lord.
Okay, use the word confession. So videography on the statements under section 161 was used to convict.
And my lord, one more thing, my lord. The defense witnesses, before lordship goes to the entire evidence, the defense witnesses have said they were traveling in a sumo vehicle. The accused appellants did not have that gate pass to enter Arunachal Pradesh, my lord. They were made to get down, my lord. Accordingly, they got down, my lord. Defense witnesses. However, in 313, my lord, both the accused appellants have said that they were in a bus, my lord.
They were the bus.
In a bus. They did not have the gate pass.
No, the defense witnesses said what?
Sumo.
Everyone was in the sumo,
Sumo.
even the accused.
With the accused, my lord, they got on at different points, my lord, but they were stopped because of gate pass. T13, my lord, they said bus.
Just a minute. And then Yes. 313,
In 313, they said a bus, man. They
who said a bus?
the
The
accused-
appearance.
Yes, man, they said bus. They did not have gate pass. They were made to come down, man.
They did not travel in a sumo.
They did not say sumo, they said bus, man. So that principle is there, मतलब false explanation of 313 would be an additional circumstance. Only if all the other circumstances are proved, it can be taken as additional circumstance. मतलब
Lens credence.
lens credence, if all the other circumstances prove, man. But मतलब PW4, मतलब, he also says there was a bus there, man, with 8-9 people. But that sumo traveler, big car, मतलब, somebody might say bus, somebody might say sumo, मतलब. PW4 says there was a sumo there.
No, but then persons in a sumo will surely know who they're traveling with.
They said they were
Okay.
traveling with us, man.
No, but then you are saying that you're not traveling in the sumo.
They said bus, मतलब, I'm bringing this to your lordship attention in the forefront only, man. PW4 says there was a bus there, man, with 8-9 people there, man. PW4, man. In cross, he says there was public sitting in a bus near the where the accused were apprehended, man, or detained, man.
And the Bharat
That check gate, man. These are the incriminating circumstances against me, man. No, I will skip PW3, man.
Huh?
I will then skip PW3 first, man.
You see, they are just asking you not to go into the irrelevant evidence,
Well,
the hearsay and all. But that's no point.
1 to 11 is same only, man. Look, PW4, my lord. What you also kindly see, my lord, PW1 said that he went with PW5 and 4 to Bhalukpung check gate, my lord, where the car was stopped.
Yes.
PW4, my lord. Look, fifth line from the top, my lord.
Yes.
On that day, about 10:30 p.m. at night, deceased Dinu Ali's brother, namely Ainul Ali, rang me up. He informed me that Dinu Ali was proceeding towards Bhalukpung as a driver and that his mobile phone was switched off.
Dinu Ali is the driver.
Dinu Ali is the deceased man.
This is driver.
Deceased driver. His
We'll just come back after 2 minutes.
Wait, the PW4 Milo, he went with PW1 to Halupung Milo.
Huh?
PW4 went with PW1 to Halupung Milo. PW4 is page 14 Milo.
Yes,
On the fifth line from the top Milo. On that day, about 10:30 p.m. at night,
yes,
this is Dinu Ali's brother, namely Ainul Ali, rang me up. He informed me that Dinu Ali was proceeding towards Halupung as a driver and that his mobile was switched off. Here, Malo, the car is not stolen. Dinu Ali is proceeding towards Halupung as a driver. I asked Ainul how he know that Dinu was going towards Halupung. He replied that Ninmol Datto, that is PW1, had taken the car of Osim Bhattacharya, that is PW5 Miller, and that they were proceeding to Bhalukpung. But since the petrol finished, Nirmal had Ainul to bring petrol. Therefore, Ainul had called me up for taking petrol to them. Thereafter, I took petrol in a gallon towards Bhalukpung. Along with me, Ainul and Rabi were there. I gave Nirmal Dotto the petrol and I took my car and proceeded towards Bhalukpung. I saw Nirmal Dotto's car standing near Bhalukpung check gate. Both the accused persons had been detained by the police at the Bhalukpung check gate along with Nirmal Dotto's car.
just a minute. Now, the first thing is Dinu Ali is the driver.
My lord, this is my.
This is driver. Then your apparent
Ascot Rotina.
Bhaskar Retina. And then the other one is
Umud Das, my lord, Ganesh senior then.
Kumar Das. Alias
Jan.
Jan Das. Okay. Yes. So PW4 talks about this bringing up the petrol for Nirmal and Ainul.
Nirmal and my lord, Ainul brings the petrol, man. Nirmal and Osim, my lord. And PW4 says that the deceased brother tells him that the deceased is proceeding towards Bhalukpung, my lord, as a driver. The car is not stolen, man. But then the accused Bhaskar fled and crossed the Bhalukpung gate when he saw me. He then goes on to elaborate, explain how he caught me, man, after I ran from the policeman. No other witness, my lord, who was there along with him, my lord, has deposed to this man. I too crossed the gate and chased Bhaskar and caught Bhaskar at Upper Bhalukpung. Ainul, Ravi and myself were there when we caught Bhaskar. When we caught him and were coming, two boys did marpit and broke my car. Since my car was broken down by the said two boys, I left the car there and all three of us, Ainul, Ravi and myself, brought Bhaskar to the Bhalukpung check gate and handed over Bhaskar to the police. This is a complete, my lord, exaggeration, my improvement. No other witness deposes to this effect, my lord. Witnesses were who were there with him, my lord. After some time, Charidwar PSIC reached the Bhalukpung check gate. All of us, including two accused, were brought to the Charidwar PS. Inquiry was conducted in Charidwar PS. Accused Bhaskar and Jan, alias Kumut confessed before the police that they had strangled Muhammad Dinu Ali and thrown his body in the Brahmaputra. The IC so and so asked the accused to show them the place where the body had been thrown. Next day morning at about 5:30 a.m., we were taken to Bharali River by the accused. We were about 8-10 boys along with the police party. The accused showed us where they had thrown the dead body. We found the dead body of Dinu Ali near the Bharali River in the side of the river. The dead body was taken by the police. Across, my lord. My lord, can you come to the last few lines, my lord? There were about 7-8 police personnel at the check gate. There were public sitting in the bus. There may have been a couple of persons near the gate. I do not remember clearly. Page 15, last one.
15.
Turning the page, my lord. The page 16, my lord. I'm reading between the lines, my lord. 8th line, my lord. We were taken to Charidwar PS at about 12:31 p.m. at night from Bhalukpur. Accused were taken in custody by the police at Bhalukpur. We reached Charidwar PS at about 1:32 p.m. It is correct that the accused confessed before the police. Well, again, leaving aside a few lines, my lord. It is correct that we found the dead body near the Bharali River. The place of recovery perhaps falls under Jamuguri PS. As the police rang up Jamuguri PS in my presence, it informed about the dead body. It is incorrect to suggest that I did not tell before the police that Bhaskar had killed and thrown Dinu Ali in the river. I knew the name of accused Jan from prior to the incident. I came to know the name of accused Bhaskar when the police informed me that the said accused was known by the name Bhaskar. It is correct that both the accused persons were handcuffed and traveled in the police vehicle when the accused persons led all of us to the Bharali River. It was about 5 p.m. in the morning. The PW5, my lord, he is Asim, my lord. He also goes with PW1. The 4th line, my lord. About 2 years back, page 17, my lord. About 2 years back, about 8:39 p.m. at night, I was in the center. Nirmalda came and told me that Muhammad Dinu Ali had taken his car to Lokhra and he was worried since the car had not returned. We, that is Nirmal Dotto, Narayan Kurmi and myself, waited for some time. But since Dinu did not return, we went to Lokhra. We did not find the blue color Alto car of Nirmal Dotto in Lokhra. Thereafter, we searched a little bit. We reached Saidra Forest Gate and inquired, but were told that no blue Maruti had come that side. We went away. Again, after some time, we returned to Forest Gate and asked the same question. We were told that one blue Maruti car had crossed the gate in high speed. Thereafter, we went to Bhalukpur. My car's petrol finished near Sotai. Nirmalda informed Charidwar PS and informed about his missing car and that a blue Maruti was seen to have crossed Charidwar check gate in a high speed. Then Nirmal Malla calls for the petrol money. Page 18 is the leading to discovery part again, madam. Kindly similar, the accused persons, Alto car were brought to the Charidwar PS. Police inquired and asked the accused where the driver of the Alto car was. First, they said that driver had gone to visit a relative. Later, in the morning, the accused persons confessed before police that they had killed the driver Dinu Ali and left his body near Bharali River. Both the accused then led the police party to the Bharali River where we found the dead body. Cross, my lord. Look, when I reached 10th line from the top of cross, my lord. When I reached the Bhalukpur check gate, Janmoni informed us about the involvement of the two accused persons. Police had kept the accused persons in the lockup and police interrogated the accused one by one in the IC's room. This is in Assam, Charidwar, not at the gate, check gate. I cannot say how many police were there in the room of the IC. I cannot say where Nirmal Dutta was standing. Ainul Jan and myself standing near the door of the IC's room. It is incorrect to suggest that the accused did not confess before the police. It is correct that the accused were handcuffed and taken in police vehicle when the accused led us to Parali River, where they showed us the body of Dinu Ali. The area fell under Jamagodi PS, and police personnel from Jamagodi PS had also come. The accused had left the dead body near the riverbank. It is not a fact that did not tell the police that dead body was recovered from the riverbank. PW6 is again Malo, same story, Malo. They go with the PW1 and everybody else. The PW7 may read.
Carry on, carry on. We're listening.
A bit long way. PW7 Malo cross part Malo. It is correct that I do not know English and I signed on Exhibit 3 because the police asked me to sign at Chaidwar PS. Exhibit 3 is the seizure list, my lord, whereby the vehicle was seized from Arunachal police. Arunachal police has seized the vehicle from us, my lord. But the seizure list, my lord, our names are not there, our signatures are not there, my lord. But it is correct that Nirmal's car is given on rent. I had not seen who had taken his car on hire on that particular day. Page 23, my lord. It is correct that I had seen the car outside in the Bhalukpung check gate, and one accused was inside the check gate of his room and the other was outside. The accused were taken to Chaidwar PS. I do not know the manner in which the Arunachal police caught Nirmal's car and the accused. I cannot say when the accused said, I cannot say what the accused said to the police. I did not myself hear the accused admitting the guilt before the police. Police later came and told that the accused had confessed before them. And then I came to know about the same. I cannot say whether the accused were handcuffed when they were taken to the Bali River. I came to know the name of the accused as Bhaskar from the police later on. PW8 is that Ainul, my lord. Although his name is different, my lord, he must be Ainul, my lord. He's the one who goes to give the petrol, my lord. Page 24, my lord. Muhammad Johrul Islam, my lord. PW8, my lord. On 17/1/2012, at about 10 p.m., Nirmal Doctor rang me up and informed that the car which my brother was driving was possibly taken away by someone, my lord. It goes on and on, my lord. Then again, my lord, the accused admitted before the police that they killed Dinu Ali, strangulating him. I was present when the accused admitted their guilt. Next morning at about 5 a.m., the accused persons took all of us near Bhavali River to show the dead body. They showed us the dead body, my lord. All the witnesses till now, my lord, the exact words spoken by the deposed to by the accused persons, they have not stated anything regarding the exact words, man. How the body was discovered, where the body was discovered. Well, in cross, my lord, he says that page 25, my lord, fifth line, Lordship would see, my lord. It is correct that the dead body of Dinu Ali was found across the overbridge on the other side of Bhavali River, man. The place keeps on changing, man. So 9 again, same, man. 10 again, 10 also again, same, man.
We'll come at 2. It's a recurrence.
In my own sister, elder sister.
Oh.
And the other request is they have taken a new point, like section when the charges were under 302 read with section 34.
34.
Conviction cannot be independently on 302. For that, I have to take out judgments. I have to see. That's a law point which I have not gone into. So I'll make my replies on Monday if they can finish it today.
You won't finish it at the rate he's going. He'll finish next week Monday.
No.
No, man.
So Monday, my humble request is as a first item,
No.
Barthad matter.
How long will you take? You're only on PW8. The 22 PWs. You've already taken around 1.5 hours. So how long will you take?
Well, I'll skip over some PWs, मतलब 25 minutes, मतलब replace my judgments and done.
Then you can leave. You have to leave.
No, I'll be there, it's okay. I'll leave after I finish this.
So, and then
My brother-
what about the next council?
On taxi is already something. On law point.
Her from family is there, daughter and son-in-law are doctors. And my brother, so she said that you come when.
How old is she?
She'll be around 62, 60.
Your elder sister.
My eldest, she is around 22 years elder to me. She'll be
My
no,
God.
65. She's almost like my mother.
She's 62,
64.
64.
We can also continue on Monday then, मतलब Monday senior student.
Huh?
No, he said that even he can do it on Monday.
If my Leonard senior, मतलब
Which senior?
No, no.
for the
he-
state, मतलब not my senior, my senior for the state, if he has to do it.
Ah, no problem. We can always adjourn the matter. It's family is important.
No, Monday, then Monday again, they will take another 1 hour, no?
That is the problem. He will take. The
No,
rate
but-
is going.
And he'll
Nah.
collect more things by
Yes.
Monday.
Yes.
So let him finish today. Then I'll be here for another.
You remind me of that train. What was that train that we used to take when we were young from Delhi to Guwahati?
Hmm.
Used to take 3 nights, 2 days.
What are some?
Huh?
Avadasam.
No. What was the another one? Huh? Brahmaputra. 3 nights, 2 days. You have to go, you'll be fully prepared.
Yes.
Enough water and whatnot.
Nowadays, I don't think so.
Huh?
Nowadays, it
No,
takes around
I
one,
don't know.
one
Nowadays we don't even travel by train.
day. That is what.
The fastest train we had was the Rajdhani from Calcutta to Delhi. Took us, I think, 24 hours or 18 hours. I'm not sure.
So am I?
So
not-
he's got to, you have got to change your engines.
Well,
Otherwise, you've got to keep us also, attentive to what your submission. Because you had said in the very beginning that the evidence of PW 1 to 11 are the same.
same.
The only thing is that they did not say exactly what the appellants had said at the time of recovery of the body. That was their main. And now you're having said that, you're reading out.
Because they
everything.
keep on changing that place of where the body was found.
Correct. That's what the other thing is that you keep on changing the place where the body was recovered. So you have said that. That's enough. If you keep on reading, you already said that. That is one of your points.
Then Malad, I'll directly go to PW 11, Malad, that videography partner.
Videography, yes,
Yes, PW 11, page 29.
yes.
11 and 12, Malad, both videography, Malad. I'll only read one.
Page,
Page 29, Malad.
page 29, PW
11
11.
and PW 12 is also same, Malad. Videography. Malad.
Now that it is live streamed, so I can see it, so I can leave if your lordship, my learned senior
No
friend
problem.
will be there. Lordship, I can see his arguments, then I'll be there on Monday.
You don't drive the car.
Lordship,
You don't drive a car.
and I drive a car. I drive a car.
Yeah, how are you going to see? both?
No, afterwards.
Oh,
Recorded version, it's available.
I thought, okay, right.
Obliged, Lordship. I'm very well.
Page 29, Malad, PW 11. Malad.
Yes,
We're on so in the 22, 1, 2000, it should be 12, Malad. Is wrongly typed as 2001, Malad. 22, 1, 2012. The IC Shahidwar PS called me for videography. I came to Tezpur Sadar PS along with my Sony DVD camera and my helper Nazir Khan to do photography for the police. There, that is at Tezpur Sadar PS. I did video recording or confessional statements of the accused person. Thereafter, on the basis of the confessional statement of the accused persons, I was asked to accompany the police personnel to
So,
Balipara.
so this is of no use.
This is sorry, like no, then I'll skip him. They from Balipara, they go to Lokhra. From Lokhra, they go to my lord, Jia Bharali Riverman to reenactment. Balipara to Lokhra, Lokhra to
In the presence of the police.
presence of the police. In police custody, my lord, they are taking my. PW 13 to 17 are now the Arunachal police personnel.
PW 13 to 17.
17 are the Arunachal police personnel. 13 is the main person, my lord. He was the in charge, my lord. I'll leave on 13. Page 33, my lord.
Yes,
13 to 17, my lord, same. Page
yes,
33.
yes.
During January 2012, I was functioning as an officer in charge of Halupung PS. So and so, my lord. Accordingly, I communicated to my check gate staff of Halupung to be more alert and vigilant. Thereafter, some time, the accused persons reached at the check gate with alto bearing number the stolen vehicle, my lord. My staff caught the accused persons at Halupung check gate and informed me. I asked the staff of the check gate to bring the accused persons to Halupung police station. The accused persons were brought to the police station along with the car. So since the place of occurrence was in Assam, I immediately handed over the accused persons 3 numbers of mobile phones, the alto numbers so to IC Saidu. Cross, my lord. When the Chaidwar police informed me over phone, I was near the check gate in the market. Chaidwar PS did not tell me the case number in the context of which they had informed me. I did not make any GDE entry when the phone call was received by me. I did not remember whether I later made a GDE entry respect the phone call received by me from Chaidwar PS. It is correct that I have not brought the GDE diary in the court today, and I have not given the same to the Chaidwar PS also. I was not told to bring the GDE diary. It is correct that when the accused persons were brought to the Bhalupung PS, GDE was made, but did not give the extract of the same either to the police or Chaidwar, nor I have brought the same to the court, as I was not asked to bring the same. It is correct that I formally did not seize the car from the accused person. I had just handed the accused persons and the car and mobile 3 numbers to the Chaidwar PS personnel. It is correct that Exhibit 3, by which the vehicle was seized, my lord, was prepared by Chaidwar police personnel. It is correct that in Exhibit 3, time is not mentioned. It was after 2 o'clock at 12 o'clock at night, my lord. All these police personnel, my lord, they will say the same thing that they stopped the vehicle, my lord, but there is no documentation that they stopped us, my lord, that they seized the car, my lord, that they arrested us, my lord. And those PWs, my lord, I have.
No, but then they have said they stopped you. That's enough. They have not.
In the seizure list, my lord, nothing is there, my lord. Even our names not find mentioned, my lord.
In who's the season list?
Seizure
Made by the charity
Chaidwar police at Bhalupung.
at Bharat.
And my lord, I forgot one thing, my lord, PW 7, 8, and 10, my lord. They have said that when they reached, we were not detained by the Arunachal police personnel, my lord. We were standing there with the personal police personnel next to the bonfire, man. This lets credence to the theory, our defense that, my lord, we were only brought down because of gate pass, man. That I had missed out, my lord. I'm sorry, my lord. 7, 8, and 10, my lord. 1 line in cross, my lord.
PW
7, 8, and 10, my lord.
7, 8, 10. What is the stand? That
They did not see us detained, my lord. They saw us standing next to the police, next to the bonfire. Man. But it was night, man, there was a bonfire going.
next to police. Near the bonfire.
Yeah, bonfire. Man. Page 138 is the seizure list, man, of the car, man. Car in the mobiles, man. Page 138. Man.
Yes.
Lordship would see, my lord, Childward OP GDE number 322, my lord. This is that GDE entry made by PW1, my lord. This is the first FI which is not exhibited, my lord. That GDE entry, my lord. The instant FI, my lord, is EDE number, my lord, 341.
No, so this Caesar list, what about it?
Scissor list, my lord, our names find no mention, my lord. I, ASI, Bhagwan Rekha, so and so, do hereby seize the following vehicle and other items which were handed over by OC Phalokpung PS, Arunachal, in connection with the above reference GDE number in presence of local witnesses. That the vehicle, mobile phones were seized from us, my lord, handed over, nothing is there, my lord. Our name is also not mentioned, my lord. Description of seized items: one Maruti vehicle, Maruti Alto LX, bearing number so in the 3 mobiles number.
Then next,
Then, my lord, PW18 is the Assam police personnel, my lord. I would skip him, my lord. He again says same thing. He was there at the time of videography, my lord.
page
Page 44.
18.
PW18, page 44. He says that he was there at the time of the videography, my lord. He signs that seizure of that cassette, my lord. Video cassette. PW19 again, my lord, like 1 to 10, my lord.
He is a businessman. PW 18.
Police only. Oh, sorry, my lord, businessman. I read the the down portion, my lord. I see Chidwa, of course, call me. He was there during the videography, my lord. I came to test for. He's a businessman, my lord. PW19, my lord, is a villager, my lord. Daily laborer from Tezpur, my lord. This is a witness, my lord. PW19, my lord. Of that exhibit 3, my lord, that I showed, my lord.
Exhibit 3 is page
128, my lord, that I showed, my lord.
130.
128, my lord. $138. I beg my loss pardon, my lord, 138. PW20 is now a hostile witness, my lord. He has been relied upon by the learned court below, my lord. And the thing relied upon is, my lord, that he heard a vehicle moving towards Balipura, my lord. And he saw a car going towards Balipura. Page 50, my lord. One night at about 9 p.m., I was resting at night. My house is near the road. I heard sound of a car being turned on the road. On hearing that sound, I came out of the house. I saw the car was going towards Balipura. On the next day, I learned that one dead body was recovered in the Jia Bhavali River. I went there. Police personnel were there. Known persons of the persons who had died were also there. I saw the accused persons handcuffed and being made to sit in the vehicle. This has been used as the incriminating circumstance to convict me, my lord. Was learned court below. That he heard a sound of the vehicle going, and then when he came out, he saw that we were handcuffed, my lord. EW21 is now the IO, my lord. One of the IOs, my lord. Page 52, my lord. Well, that GDE number is GDE number 322, dated 17/1/2012. That was by PW1, my lord. But you can turn the page, well, PW53, my lord. The accused persons confessed that they had stolen the auto number car so and so so and so. They also confessed that they had killed the driver of the said car, namely Dinu Ali. The accused person stated that they could show the place where they had thrown the dead body of Dinu Ali. Thereafter, the two accused persons led us to the place where the dead body of Dinu Ali had been kept by them. On being shown by the accused person's dead body of Dina Ali was recovered from Jia Bhawali River. The recovery part goes, my lord. Then, my lord, 10th line from that part, my lord. He says that PW3 then again makes a fresh FIR. Well, then I will skip all of that, my lord. Lordship, can I come to page 56, my lord? Kindly, my lord. First line, my lord.
Yeah.
56, my lord. It is correct that I did not record the leading to discovery/recovery statement of the accused persons. Then on page 57, my lord. It is correct that Tonkesor is PW20, my lord, used by the current trial court to convict us, my lord. It is correct Tonkesor stated before me that he had heard about the occurrence from others. Tonkesor is PW20, my lord. He is hostile, my lord. He was relied upon by the trial court, my lord. PW22 is again another IO, my lord.
Second IO or first IO? What? Who is the first IO?
Main IO is 21, my lord.
There were two IOs at the same time.
22 is the one who went to Bhalukpung, my lord. Twenty-two informs Bhalukpung check gate that the car is traveling. 22. But he says that the dead body was recovered from an open space, my lord. Cool. Well, page 59, my lord.
Page 59. Yes.
The dead body was recovered near the bank of river. A little below in the water, it was floating in the water. Then, my lord, there are three defense witnesses, my lord, DW 1, 2, and 3. They state the same thing, my lord. Page 61 is DW 1, my lord.
Yes.
I know the accused persons Kumud Das in the dock. I also know Bhaskar Jyoti not in the dock. On 17 January 2012, I had gone to Arunachal Pradesh in a white sumo vehicle. The vehicle sumo was coming from Tezpur and I boarded the at Balipara at about 3 p.m. I met both the accused persons in the sumo vehicle. At about 4 p.m., we reached Bhalukpung gate in the sumo vehicle. Since the accused persons did not have pass, Bhalukpung police kept the said two accused persons at the gate and I was allowed to cross the gate and I went to Tawang, Arunachal Pradesh. I know this much. EW 1, 2, and 3. And EW 3 is the driver of the sumo. Then, page 67 is the 313 of Kumud, Manu. the other FLM, 313 of the other FLM, my lord. Same, I would not show all the 313, my lord. 67, my lord. The questions are not numbered, my lord. Fourth question, my lord, answer, my lord. They both say the same thing, my lord. That's one thing. It is false. My lord is found, my lord.
Which page?
Page 67, the fourth question, my lord.
Fourth question.
Fourth question, the answer, my lord.
Yes.
It is false. I did not confess. It is false. I did not say that I could show where the dead body was. Police had beaten me up a lot. Then judgment, my lord, page,
But where have you stated that you were in a bus?
it is there, my lord. I will show my, that one. Page 93, my lord, that is my 313.
Three one three of whom?
This is my 313. Page
What is your name?
Bhaskar Jyoti Nathpal. Page 93.
Yes.
The first answer, my lord.
Yes.
It is false. I had gone in the bus. Kumud was sitting in the first row. Since we did not have pass, we were asked to get down. I did not go with the car. I cannot say about the car. The car meaning the Alto, my lord. Kumud says the same thing, my lord, page 75. It is false. I had gone in a bus.
Now, DW. They said that you were in a sumo.
Sumo.
You said that you have gone in a bus. So basically, the DWs were lying.
Well, sumo bus. Well, I will only say one thing. PW4 says that there was a bus there.
No,
It
that
might
is-
have been that big traveler, that vehicle, my lord. Not the normal sumo, my lord. Maybe, my lord.
Maybe, okay.
Very
Then,
vague, my lord. Maybe, my lord.
okay, then.
Then, my lord, the judgment, my lord. My lord, page 126, my lord.
Yes.
Now, these are the points, the circumstances on which I've been convicted, my lord. So, number one, my lord. First, auto car of Nirmal Dotto and his wife gone missing with driver. That itself, I would humbly argue, my lord, is not proved, my lord.
Page 126.
126, internal page 27, my lord.
Yes.
Point number one, my lord. First, auto car of Nirmal Dotto and his wife gone missing with driver, my lord. That will humbly argue has not been proved, my lord. All PWs give conflicting views, my lord, that the driver had taken the vehicle. They went in search of the driver, my lord. Car was stolen, something. All different, my lord, views come up to light, my lord. Second point, my lord, PW20, my lord, the hostile witness, my lord, whose house is near the road, heard one car turned on road. And when he came out, he saw the car being moved in Balipara direction. 20 had never said that he saw the Alto vehicle going, my lord. Even the only thing he said he heard, my lord, from other persons that this has happened now. Point number three, my lord, at Chaidwa check PW1527. While searching the car, got information from the person of Chaidwa Forest check gate that one blue color Maruti gone in the direction of Bhalukpung at high speed. Then 4, my lord, PW1 then immediately informs the police, my lord, Chaidwa police. 5, the OC Bhalukpung 13, PW13 alerted the staff, my lord. They hold the accused with the Alto car, my lord. Then, my lord, PW1 to 4 to 10 with other staff reached Bhalukpung and all of them saw the accused person and missing car And Bhalapung police handed over accused person recovered car and other materials seized by them to Charidwar police. Now, this does not speak about how they were seen, my lord. They were seen next to the bonfire. There is no document that the car was seized from them, my lord. Then, my lord, during interrogation, accused admits killing of driver Dinu Ali, driver of the car. And this fact is admitted by other PWs present there about admission of the accused person. But this is in presence of policemen. This is inadmissible, my lord, section 25 of the Evidence Act. Then, my lord, point number 8, my lord. Accused led police to bank of river Korali, where the accused person shown dead body of Dinu Ali. Dead body of Dinu Ali recovered at the instances of the accused person in presence of witnesses. PW 1, 4 to 12, 18 to 19. PW 21, 22 are police personnel in IO of the case. The leading to discovery is completely hid by the judgment later on Supreme Court. Honorable Supreme Court. And then the last point again, the hostile witness, my lord. PW 20, whose house is near the river Bhorali, came to the place of the recovery of dead body. Learning about it, saw accused person, other PW and police at the place where dead body of Dinu Ali was recovered. It was at best a hearsay witness. The first one is it's called Bobby, my lord, 2023. SCC online SC, page 50, my.
Which one?
Bobby, my lord, 2023. SCC online SC, page 20, my. Page 50, my lord.
Yes, para.
Well, para 22, my lord. Where is found, my lord. The High Court further found that insofar as Bobby, accused number 3 appellant herein, was concerned, there was an additional evidence with regard to the recovery of the dead body and ornaments. Insofar as Shibu Singh, accused number 1, was concerned, the High Court found that the recovery of spade, which was used to dig the burial site where the dead body was concealed, was an additional circumstance which proved the guilt of Shibu Singh. Then, can you turn to page para 29, madam? Mary, this court in the case of so and so had an occasion to consider the evidence of recovery of incriminating articles in the absence of record of statement of accused number 1. In the said case, no statement of accused number 1 was recorded under section 27 of the Evidence Act, leading to the recovery of jewels. The court found that the Sessions Judge as well as the High Court had erred in holding that the jewels were recovered at the instance of the accused number 1. Therein, in pursuance to the confessional statement recorded before PW 34 therein, it would be relevant to refer to the following observation of this court in the said case. Thus, the fact remains that no confessional statement of a A1 causing the recovery of these jewels were proved under section 27 of the Evidence Act. Paragraph 30. It is thus clear that this court refused to rely on the recovery of jewels since no confessional statement of the accused was proved under section 27 of the Evidence Act. Then, paragraph 31, kindly turn the page, it's marked in bold, madam.
Yes.
The paragraph 31, kindly turn the page, madam. It's marked in bold, madam. It's another Supreme Court judgment, madam. It is therefore necessary for the benefit of both the accused and the prosecution that the information given should be recorded and proved. If not so recorded, the exact information must be adduced through evidence. The basic idea embedded in section 27 of the Evidence Act is the doctrine of confirmation by subsequent events. The doctrine is founded on the principle that if any fact goes so on, my lord,
Yes.
The exact words deposed by the accused appellants must be brought on record, my lord. And now these are division bench judgments, my lord, of the Honorable Supreme Court. Then, my lord, para 32, my lord. A 3 judges bench of this court recently in the case of Subramanya by the state of Karnataka has observed that, internal that page, para 83, the first and the basic infirmity in the evidence of all the aforesaid prosecution witnesses is that none of them have deposed the exact statements said to have been made by the appellant herein, which ultimately led to the discovery of a fact relevant under Section 27 Evidence Act. 84, my lord, if it is say of the investigating officer that the accused appellant, while in custody on his own free will and volition, made a statement that he would lead to the place where he had hidden the weapon of offense, the site of burial of dead body, clothes, etc., the first thing the investigating officer should have done was to call for 2 independent witnesses at the police station itself. Once the independent witnesses would arrive at the police station, thereafter, in their presence, the accused should be asked to make an appropriate statement as he may desire in regard to pointing out the place where he is said to have hidden the weapon of offense. When the accused, while in custody, makes such statement before the 2 independent witnesses, punch witnesses, the exact statement, or rather the exact words uttered by the accused, should be incorporated in the first part of the Panchnama. This part of the Panchnama, for the purpose Section 27 of the Evidence Act, is always drawn at the police station in the presence of the independent witnesses so as to lend credence that a particular statement was made by the accused expressing his willingness on his own free will and volition. My lord, here, my lord, not to talk about the Panchnama, the discovery memo, my lord, even the witnesses are not deposed, my lord. These are the exact words, my lord. Then, my lord, that Subramanya, this judgment has referred to, my lord. I have placed, my lord.
Yes,
You can turn to para 71, my lord.
yes.
In this judgment, my lord, the deposition of the witnesses in this case, my lord, was brought in, my lord. Para 71, my lord. For the purpose of proving the discovery of dead body of the deceased at the instance of the appellant herein, the acquitted co-accused A2, the prosecution has relied upon evidence of PW7, so and so, my lord. Next day, when the police and the assistant commissioner came to the spot, I was also called there. CW2 to 4 were also called. That A1, A3 showed the place where they had. There A1, A3 showed the place where they had buried the body of Kamal Lamna to us and also to the police and the assistant commissioner. Thereafter, with the help of PW3, the report of Kamal Lamna was exhumed. Can you turn the page, my lord? 72. On so and so, CPI called me. CW2 and 3. At that time, assistant commissioner was also present. A1 Subramanya, A3 Sitaramana Bhatt were also present. From Gadikullu, police officials AC, A1, A3, along with me, CW2, 3, we went to the place where the body was buried. A1 took us to the said place where they had buried the body. After showing the place where they had buried the body of the deceased by A1 with the help of PW3, the body was exhumed. And there we noticed that it is a dead body of Kamal Lamna. Then all the PWs are there, my lord. Para 77, my lord. I've read that in the previous judgment, my lord. The first and basic infirmity in the evidence of all the aforesaid prosecution witnesses is that none of them have deposed the exact statements said to have been made by the appellant hearing, which ultimately led to the discovery of a fact relevant under.
If there is already one judgment to what you have said in support of your submission, why is it required to quote another judgment?
No, because
You
in
mean to
this,
say 2-3 judgments will look appear to be more stronger or something?
no, because in this judgment, the depositions are brought out. The depositions show, here though something is better than our case. In our case, they led us to a dead body. In our case, the present case, the PW just say that they showed us a dead body. That is why we only showed the judgment.
How many judgments have you got?
3 men. 3 more men.
Your 25 minutes has stretched to 45.
Lost pardon, I'm done. Please all of them together. replacing all three together. Regular less party. Well, first, I would like to rely on this is Tulesh Kumar Sahu man. 2022 live law SC 228. What you just seen, madam?
Yes. No, you need this, you need it right.
Tulesh Kumar Sahu man.
I don't have that. Suresh Kumar Sahu, I don't know. You must be having two. You might be having two. You've got another one. Ah. Suresh Kumar. Yes,
Para 33 madam.
yes,
What you kindly read the preceding para of 33 madam.
33.
Internal 33 madam. There is 12 madam. Preceding para of 33 madam. Kindly madam. It's underlined by the honorable court madam. It's not numbered madam. Where, however, the only evidence against an accused person is the recovery of stolen property. And although the circumstances may indicate that the theft and the murder must have been committed at the same time, it is not safe to draw the inference that the person in possession of the stolen property was the murderer. Suspicion cannot take the place of proof. Question 33, madam. The first thing to be established is that theft and murder forms part of one transaction. Here, the prosecution has not led evidence to that effect.
Okay, carry on.
The circumstance may indicate that theft and murder must have been committed at the same time, but it's not safe to draw the inference that the person in possession of the stolen property was the murderer.
Next.
Then, Munni Krishna Lordship found.
Yes. Para.
Para 13, madam.
Yes,
It is one big para 13, madam. Lordship will turn the page, madam.
yes,
Lordship, next page, madam, the last line, madam, both the trial court
yes,
and the appellant court were completely wrong in placing reliance on the voluntary statement of the accused and the videography statements. And the articles so and so, the accused cannot be compelled to witness against himself. Again, under section 25 of the Indian Evidence Act, a confession given by an accused before a police person is inadmissible in evidence. And then, madam, videography evidence is not evidence for next parameter.
yes,
This is for the videography part, madam, and the police part, madam. And then, madam, last, madam, that 2021 5 SCC 626.
yes,
Sivaji Chintappa Patil.
yes,
Para 25, madam.
yes,
Another circumstance relied upon by the prosecution is that the appellant failed to give any explanation in statement of 313. By now, it is well settled the principle law that false explanation or honest can only be used as additional circumstance. Additional circumstance when the prosecution has proved the chain of circumstance leading to no other conclusion than the guilt of the accused. However, it cannot be used as a link to complete the chain.
correct.
My lord, I'm done. I'm finished. Man. I will humbly submit that, my lord. Apart from that car, my lord, which also not been proved to be recovered from us, my lord. The other circumstances are not proved, my lord. Not at all proved, my lord. Obliged, my lord.
Yes,
Lordship. May I please the Lordship? I am appearing on behalf of the other accused, that is Das Elias Jan. Now here in this case, prosecution's case is that these two persons along with the car was intercepted at Bhalupung PS gate. But Lordship will kindly say for the evidence, there is nothing on record to show that there was any entry in the Bhalupung police station. No entry at all. Even they have stated that they have handed over to the Saridwal police station. PS, the police, they went there. They have seized the car along with the accused they have brought to Saridwal police station, Lordship. Even that is, there is nothing on record to show that they were taken in custody from Bhalupung PS. Then they were brought to Saridwal. Then your Lordship kindly say the exhibit 3. According to the prosecution there, that we have been picked up along with the Alto vehicle and the other 3 mobiles were seized from us. That page 130 also will kindly say exhibit 3. There's nothing on record to show that it was seized from our possession. Not a single line that the vehicle was seized from our possession and the mobiles. And moreover, this seizure list was prepared at Saridwal OP, not at the place of occurrence. That is, and there is nothing on record to prove that it was seized that.
look, we've already gone through the evidence. There's no point.
No, I'm not gonna, just a submission I'm making. Just seizure list, that this is vital, Lordship. Because they have to, prosecution cases that we have been apprehended there along with the vehicle and the mobiles. Those things are not there in the Bhalupung PS. Neither in the seizure list is mentioned it was recovered from our possession. That's what is very, very vital. That's what I'm showing you, your Lordship. And even the signatures of the accused persons are not there. They are ought to have taken it. And the independent witnesses who were there, they have not supported the prosecution case. They have stated that they have signed on a black piece of paper.
Take us to the seizure list.
130 please. Exhibit 3, page 130.
Please read.
I as ASI Bhagavan Deka of Saridwar PS, Rangapara district, Sonitpur, do hereby seize the following vehicle and other items which are handed over by OC Bhalupung PS, Arunachal Pradesh, in connection with our reference GD number in presence of local witnesses on this date, 18 January 2012. Date of time of seizure, 18/1/12. Place of seizure, Bhalupung PS AR. So, description of seizure article. So,
Seizure made at Bhalupung.
where is the record? In the Bhalupung PS, there must be a record that they have handed over these articles to us. To the Saridwar
Bhalupung
police
PS
station.
did not seize. The seizure was done by somebody else.
That you'll also kindly see. Now, next page you'll also seized by so and so, and this seizure list was prepared at Saridwar PS, not at the Bhalupung. And the witnesses will also will kindly see. They are also all from here. Janmoni Sharma, Ravi Basak, they are from here only, from Assam.
So how do you say that it was made in the Saridwar PS? Where?
Also can seized by, yeah, it is written.
Seized by.
ASI Bhagavan Deka, Saridwar P, Rangapara, PS Rangapara,
He is of
dated 18/1. So occurrence took place in the night. So 18 it was seized. On 17/1/12 it was occurrence took place. And the seizure list also will say it was 18/1/12. So necessarily this was prepared at Saridwar PS. And most important part is this, they have not mentioned from whom it was seized. Whether it was seized from Kubudnath, whether it was seized from Bhaskaravati. That has not been mentioned in the seizure list. Only on the basis of Saridwar OPGD number so and so, 322, and you'll also can see the GD entry also. The IO has exhibited the GD entry, that is page 161, you'll also can see. That's GD entry number 322/12. Page 161, that you'll also has not seen. Prosecutor got it, 161.
Yes.
Extract copy of Saridwar OPGD number 322, dated 17/1/12. Now see, Nirmal Dr. Balipara informs our phone that some miscreants have lifted his car bearing number so and so and have gone towards Bhalupung, Arunachal, by driving it in a very fast, and that the informant and the others have been following that car. I immediately informed the matter of Bhalupung PP over phone
And Bhalupung check gate and Bhalupung peers over wireless, asking them to keep the car in their custody if found. I accompanied ASI B Deca, a section of 12 APBN, and started proceeding towards Bhalupung PS, so and so remain in charge of OP. So these people, they went to Bhalupung. Thereafter, they have brought the accused along with the vehicle to Saripur. But in Bhalupung, no entry, nothing at all. They have informed to GD entry number. That part will also be kindly see. And moreover, another important law point is involved in this case, because charge year lordship was already seen. It was all 302 by 34, then 392 by 34, then 201 by 34. And in the judgment, you'll also kindly see the conviction part. That page, lordship. Page 127, lordship fine.
Page 127.
127. Para 60. Para 60 lordship. Thus, I have come to my considered opinion, the accused Bhaskar Tinat and Kumud Jan has committed couple within the ambit of section 299 IPC and accused strangulate Dino Ali till he takes his last breath only to rob him of his car. And thereafter accused thrown the dead body of deceased in the bank of river Jia Bharali, in short river Bharali referred above, with intention to screen them from legal punishments pursuing fairly, able to establish charges under section 392, 302 by 201 IPC. Against the accused person beyond all reasonable doubt, I find accused Bhaskar Tinat Kumud Das guilty of commission offence under 392, 302 by 201. So accordingly, 364 they were acquitted and they have been convicted. Now you also will find from the Supreme Court judgment, unless there is charge of the substantive offence, one cannot be convicted. Because here the substantive offence is 302. Substantive offence. In this case, Lordship will kindly find 1993 3 SSA 32, page 32. Here, Lordship, the Supreme Court has held in 1993 3 SSC, page 32.
This is 1995.
90, I have given.
Yes.
Here you'll also find, after framing charge for offence under section 302 by 149, accused cannot be convicted for substantive offence under section 302 simpliciter. So here simpliciter
Page.
in the para 11, this is 1993 SCC page 32. In the head note you'll also find.
I don't want head note.
Then page para 11 you'll also find. Page 37, para 11.
Yes.
Since appellant number 1 Subran had been charged for the substantive offence of murder under section 302 IPC, even the trial court which tried the 6 accused persons was not justified in according a conviction against him for substantive offence of murder punishable under section 302 IPC. After framing a charge against him for the offence under section 302, read with section 149 only. A person charged for an offence under section 302 IPC, read with 149, cannot be convicted of substantive offence under 302 IPC without a specific charge having been framed against him as envisaged by law. Conviction for the substantive offence in such a case is unjustified because an accused might be misled in his defense by the absence of charge for substantive offence under section 302 IPC. So that is the finding of the Honorable Supreme Court. Here also, the substantive charge was not framed. It was by 34. And in,
What do you mean? What do you mean substantive charge was
that
not
is
paid?
302. Earlier
302?
charge was for 302 and 34.
So
In the conviction, it was simpliciter 302, no 34 is there. So unless I was charged under 302 alone, then only I can be convicted under 302. Independently, simpliciter, that is simpliciter also. So here the Supreme Court has stated, because I may be misled in my defense. The earlier allegation against me was 302 by 34. That is common intention. Now in conviction only 302 is there. Common intention is also not there. So thereby the whole trial will be vitiated. Then another judgment will also find. It is 1995 SCC, criminal 175. Regarding the same issue also.
Para,
This is a short judgment also, here not it's clear also. Between husband and wife. Section 302/34, two charged, one acquitted effect when there is no independent charge. Husband and wife charged with offence under section 302/34. Absence of charge under section 302 simpliciter. Acquittal of husband, conviction of wife not sustainable. Non facts, there is no evidence to show that she is independently committed the offence. So here also same. Because 34 was earlier there. In conviction that 34 was not there. So thereby the trial has been vitiated. In these two cases, the Supreme Court has given benefit to the accused lordship. And so far, section 27, that statement not recorded lordship, I would like to cite only one decision I would like to cite lordship. There's a both draft 2028 SCC page 45. Because here also the IOE has not recorded statement of the accused person prior to recovery of that dead body lordship. That you also will find in page. Page 59 you also will find.
para,
Para 18. Para 18 and last part you'll also will find page 59. In other words, the exact information given by the accused while in custody, which led to recovery of the articles has to be proved. It is therefore necessary for the benefit of both the accused and the prosecution that information given should be recorded and proved, and if not so recorded, the exact information must be adduced to evidence. The basic idea of embedded in section 27 evidence Act is doctrine of confirmation of subsequent events. The doctrine is founded on the principle that if any fact is discovered as a search made on the strength of any information obtained from a prisoner, such a discovery is a guarantee that the information supplied by prisoner is true. The information might be confessional or non-inculpatory nature, but if it results in discovery of fact, it becomes the reliable information. It is now well settled that recovery and object is not discovery of fact, and we says in the section. This is a Privy Council for so and so is the most quoted authority. So here also this court has earlier decision he has already given regarding the same fact. The exact word must come or it should be recorded in writing. That part was not done in here in this case. And
Mr. Counsel, please give all your judgments at one go, no? One, just send it, just send the whole bunch.
only one decision is there, Lordship. Regarding two views, that you'll also know.
There's
When
only-
two views are, that part. When two views are possible, one favor in the accused should be accepted. That part. And regarding the circumstances that was relied by the trial court, the circumstances that he has already submitted before your lordship. Those are not the circumstances, that does not link the accused person, lordship. The chain is not complete. So in my humble submission, they should be given the benefit of at least doubt this, that part is there, lordship. And regarding defense witness, I'm not relying, lordship. They are going in Bahas more, that part I'm not relying. I'm on the prosecution case also. And prosecution in this case has not been able to establish the case beyond reasonable doubt.
You are not relying, but your friend is relying.
Lordship. My friend is relying, but I'm not relying. Because prosecution has to stand on its own leg. First the prosecution case, then the defense case will come. That's why, lordship.
Okay, right. Heard. Mr.
With and
N.
Mahal.
Mahajan for the appellant in criminal appeal 91/2017. And Mr.
D Talukdar.
D. Darugdar for the appellant in criminal appeal 187/2017. Ms. Al Jahan, addition, please submit that. She will make her reply on Monday, he said.
No, Monday.
This is the matter on Monday is too short.
And Tuesday also.
21.
Monday 20.
Okay, 21. But
Much.
then they have got to make the list. When will they make the list? Tomorrow, day after. Tomorrow, day after.
Tomorrow is holiday, Lordship.
Day after tomorrow.
Day after it's open. Saturday is open.
21.
May it please your lordship.
Is it a good case for you?
I think so.
Despite the confession of sin?
Confession has been rejected by the trial court. Madam. Because only 45 minutes was given to him. That is the ground. I have got judgments of this honorable court as well as the apex court on the confession part, but the confession has been brushed aside by the trial court.
And that has not been challenged.
That has not been challenged. The ground of conviction is that, my lord, the blood-stained half pant was recovered from my body. I mean, the accused, the convict's body on 27th. So I'll try and show your lordship, my lord, that that is not correct. Not take much time, my lord. If I go to that part of the, because the Caesar.
You might not take time. We will be taking time.
Because the Caesar witnesses say something else, my lord.
Because now,
Because if we are not on the confession, my lord. If we are not on the confession
we
part,
have got to, yes, I know, but then we have got other, I know, I will take some time. We'll list it some other time. Because we have got to look at some other matters also. List this matter after the week. No, that also.
আর আপনার আজ এরকম